Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. Monday morning, it's the Monday Morning Grind brought to you by our friends over at Blackout Coffee. Check them out, fantastic stuff, including our own blends here for the channel, 2A and 1776. Plus they have this cool hat and some cool other gear, Guns and Gadgets as well. Check them out, link will be down below. They can handle your coffee needs. Let's get into today's news. There's a case that's been mulling around for a very long time related to concealed carry versus open carry, and that is Young versus Hawaii. George Young is a Vietnam veteran, and the long and the short of this is, like I said, it's been going on for a very long time. In fact, Mr. Young has filed this case 3 times. At stake is this. The county of Hawaii, where he lives on the Big Island, they do not give out concealed carry permits. They have not, records show that they have not given one out to any private citizen. And they only keep their records back 20 years. So that's all we can find out, is that there are 0 concealed carry permits in the county of Hawaii for the average American that has a Second Amendment right. Now, of course, he has applied for his permit and was denied. Some other things quickly related to the County of Hawaii concealed carry application process is that there is no process. There are no written rules. There's no structure. There are no guidelines on how to apply. You can just walk in and get an application to the chief, and it is totally up to the chief if he wants to do it or not. He hasn't given anyone one yet. It's totally arbitrary, totally egregious. And, as you would imagine, since it's a cluster already, there is no appeal process at all, which is worse than most any state out there, because at least here in the ungun-friendly Northeast, at least you can appeal to a district court or what have you. Different states are different. But in Hawaii, there is no appeal process at all. Totally up to the chief. And like I said, it's just used as a process to deny people. So, being as set up as the process is, Mr. Young has had applied for an open carry permit in Hawaii. Well, he was denied that as well because Hawaii only gives those to security guards. So you have a scenario worked out where this gentleman was denied his right to carry concealed and denied his right to carry open. Well, how else are you supposed to do it? How else are you supposed to be able to keep and bear arms? Correct? You can't. So blatant issue there regarding the Second Amendment. Now, if you remember in the video I did, it's called the State of the Second. I'll have it right there, State of the Second Amendment. There are a lot of things that have changed since the Supreme Court has denied taking 10 cases up last month. And the courts are getting emboldened by this. This is why it's much more important for us now, more now than ever, to fight things at the legislative level than depend on the courts. But there are some circuits that have ruled in different ways, and that's usually what sets up a great case for the United States Supreme Court. Now, this would have to make it through this Ninth Circuit first, but let me tell you a little more about the case. This case has already gone in front of a 3-judge panel in the Ninth Circuit and won 2-1. Now it goes to en banc, which means a full court. All of the justices in the Ninth Circuit are eligible to come into this, and then they do a random draw of these 11 judges who will actually sit to hear the case. That's where this is going to get interesting. The Ninth Circuit Court of Appeals has always been called things like the silly circus, and it is the most overturned circuit in the land. They're known for being very, very, very liberal, and they make like liberals look conservative sometimes. But that has changed. The president we currently have, Donald Trump, has appointed, I believe it is 6 conservative justices to the court, which has drastically changed the makeup of that court. It still is Democrat-controlled or leaning, but I think it's only 2 justices now if you look at the split. I could be wrong. I don't have the makeup in front of me, but it is close. And what does that have to do? And that is good because when you do the random draw for the 11 justices who will hear the case, the chances are better of getting a decent shot at what the Constitution says. So what the Young case obviously is doing is suing for the right to keep and bear arms. Because you said I can't have a concealed carry permit. Well, what's left is open carry, and you said I can't have one of those too. Now how do I exercise my rights? So what the court will have to look at is, like I mentioned, there's a split. You have 4 circuits in the United States that have heard cases on may issue versus shall issue, may issue, and it's been upheld in court. And those are the First Circuit here in Massachusetts, the Second Circuit, the case was out of New York, the Third Circuit was out of New Jersey, and the Fourth Circuit case was in Maryland. And all 4 of those circuits have upheld may issue, which sucks, which is terrible. And then you have one circuit, the District of Columbia Circuit, and the D.C. Circuit once was may issue, but recently, if you've been on the channel, it was overturned. And if you weren't aware of that, now's a good time to start subscribing to Guns and Gadgets, because this is where you're going to find this information. So now you have, it once was 5 circuits that said, you know what, we're not just going to shall issue you anything, that Constitution, no, we might give it to you if you jump through our hoops. But one of them overturned. Now it's down to 4. So California, the Ninth Circuit had one case that was famous, and that's the Peruta versus California, Peruta versus San Diego. And the one thing is in that case, it never really came down to ruling on the may issue part of California's handgun laws. They only ruled on the concealed carry permit side of it. So there is a valid question in the Ninth Circuit of, well, what is going to be the law of our circuit? We have areas that are disagreeing with each other, and we're supposed to be all the same. We're supposed to be all the same in the country too, but thanks to SCOTUS, this is happening. Now, in the last month and a half, there have been a lot of amicus briefs, or amicus briefs, however is the right way to say it this week. And a lot of heavy hitters, like the who's who of Second Amendment groups, are on this list. Now, for Mr. Young, who was the appellant, you have groups such as Gun Owners of America, Gun Owners of California, Firearms Policy Coalition, Second Amendment Foundation, Hawaii Rifle Association, California Rifle and Pistol Association, Hawaii Firearms Coalition, Professors of Second Amendment Law, Firearms Policy Foundation, the Cato Institute, Madison Society Foundation, California Gun Rights Foundation, the Independence Institute, the New Civil Liberties Alliance, the National Rifle Association, and the Attorneys General of the following states: Louisiana, Alabama, Arizona, Arkansas, Georgia, Idaho, Indiana, Kansas, Kentucky, Mississippi, Montana, Nebraska, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, and West Virginia. I might have missed some because this case has been going, like I said, for a long time. Those people are all in the corner of George Young, saying this guy's rights are being violated and something has to be done to correct this. Hawaii is running amok. Now, of course, the state has people in their corner too. The Brady Group, Professors of History and Law, the Prosecutors Against Gun Violence, the Giffords Law Center to Prevent Gun Violence, Everytown for Gun Safety, social scientists and public health researchers, corpus linguistics professors and experts, the County of Honolulu, the County of Maui, and the County of, I don't know how to say this, Kauai'. I don't want to butcher it, but them. And then attorneys general from Hawaii, California, New Jersey, Connecticut, Illinois, Maryland, Massachusetts, New York, Oregon, Rhode Island, Virginia, District of Columbia, shockingly. They're all on the side of the bad guys.
So say good night to the bad guy. Come on. The last time you're going to see a bad guy like this again, let me tell you.
So now you have the states have lined up saying there's an issue here, okay? So this case is primed to end up one way or another in front of the Supreme Court. But there's still time to still a lot left here. They held this case back for that New York State Pistol and Rifle Association case versus New York, which turned out to be a sham. New York played the justices in the Supreme Court and then challenged them, and of course they quivered. And then they were waiting for those 11 other cases that were in front of the court for Second Amendment reasons, and then that went by the wayside. So now it opened up the pipeline for this Young versus Hawaii case. Now, what remains to be seen is, will the Ninth Circuit become emboldened because the Supreme Court has turned its back on the Second, or are they just going to go against it totally and make them appeal it to the Supreme Court? But either way, the movement is happening now. They've already done their en banc briefs, so it's time. The time is here, and the case is going to be moving forward. So hopefully what does this mean for us, right? We don't live in Hawaii. This could ultimately, give the people, our brothers and sisters, our family, our patriots that live on the islands in Hawaii, this could give them their shall issue. Could end up being a may issue as well. But either way, this should define some type of process for the county of Hawaii, which would also cover the state. Now, this being up at the Ninth Circuit, this is going to affect the entire circuit as well. Now, the Ninth Circuit is huge. It's Hawaii. Let me look because I don't want to screw it up. Hawaii, Alaska, California, Oregon, Washington, Montana, Idaho, Nevada, and Arizona. So this ruling will affect everybody in those states because it's in that district. And again, this could be something great for the United States Supreme Court related to carry issues. I mean, the carry issues that were, 5? I think it was 4 or 5 of the cases that were in front of them last month. A couple of them right out of New Jersey all by itself, and one here, and I think it was one out of Massachusetts as well. So it's coming to a head. Hopefully, I don't know. Hopefully. I don't have any hope. Anyway, I don't have any hope, or I don't trust the court system anymore. But let's see what these guys and gals do. And this bears watching. This is very worthy of our attention. So how can you stay in the loop here? You can do that right here. Subscribe to Guns and Gadgets. I will keep you in the loop. And who knows, maybe as this moves forward, we'll have some of the players that did briefs here on the channel. We'll see if you guys want that. We'll make that happen. And I don't know about you, but I am sick and tired of guys and gals in robes getting to decide what they determine freedom to be. It's just getting old. Thank you for your time. I know this is kind of a long discussion for this case, but it's been going on in its current ideation since 2012. And yeah, that's a long case. I think it's the longest appeal in the Ninth Circuit history, I believe. Could be wrong. All right, guys and gals, thank you for your time. Hope your Monday goes fantastic. Don't forget to check out Blackout Coffee. They support the channel, and they make some fantastic gourmet coffee. I'm hooked. What about you? Till we see each other again, be safe, stay vigilant, and carry your weapon. Take care.